हाय हेलो वेलकम एवरी वन ऑफ यू एंड आई एम डैम श्योर आपकी स्टडीज बहुत अच्छे से चल रही होगी। ओके, इंडियन पिनल कोड JIGL का एक इम्पॉर्टेंट चैप्टर है और उस इम्पॉर्टेंट चैप्टर में कुछ इम्पॉर्टेंट क्वेश्चंस जरूर देख के जाइए। ओवरऑल ये चैप्टर की रीडिंग काफ़ी अच्छी है तो पूरा चैप्टर देखना बहुत इंपॉर्टेंट है। प्लस उसके साथ साथ मैं कुछ इंपॉर्टेंट क्वेश्चंस आपको रिकमेंड कर रहा हूँ, प्लीज़ एग्जाम वाले दिन वो ज़रूर देख के जाइएगा। ओके, so some of the questions that you must be looking for your forthcoming exams, that is December 22। एक तो डिस्टिंग्विश बिटवीन क्रिमिनल ऑफेंस एंड सिविल रॉन्ग, तो ये वाला पार्ट जरूर देख के जाना है कि क्रिमिनल ऑफेंस और सिविल रॉन्ग का मतलब क्या है। क्राइम इज अ सोशल फिनोमिनन, सब जगह होता रहता है, एंड सिक्योरिटी ऑफ अ पर्सन एंड प्रॉपर्टी हैज बिकम एन एसेंशियल फंक्शन टुडे फॉर द स्टेट, एंड दैट्स व्हाई हमें एक लॉ चाहिए क्राइम से रिलेटेड। एंड फॉर डिटर्मिनेशन ऑफ क्राइम देयर इज नो फिक्स रूल बिकॉज केस टू केस डिफर करता है। The difference between a criminal offense and civil wrong is that the former is a wrong to the society or wrong against the society, whereas civil wrong is wrong done to an individual in the society. तो ये फर्क पड़ता है। And it is believed a serious crime threatened every existence of any orderly society, यानी पूरे society को affect करता है, and if the crime is committed, it is committed against the whole society। तो ये वाला part जरूर देख के जाना। प्लस इसके साथ साथ yes, write a short note on intra-territorial jurisdiction and extraterritorial jurisdiction. See the geographical areas to which एक law apply होता है और इंडियन पिनल कोड किस तरीके से एप्लीकेबल है इंडिया के अंदर और इंडिया के बाहर के अंदर। So ordinarily laws is made for the country, it has its own boundaries, it has its own territorial jurisdiction। लेकिन जब कंट्री का लॉ इंडिया के बाहर या किसी टेरिटरी के बाहर भी एप्लीकेबल है तो उसको हम लोग एक्स्ट्रा टेरिटोरियल जुरिस्डिक्शन बोलते हैं। वह IBC इंडियन पिनल कोड की बात करूँ तो क्रिमिनल कोर्ट्स इन इंडिया दे एक्सरसाइज द जुरिस्डिक्शन फॉर क्राइम विच इज कमिटेड इन द टेरिटरी ऑफ इंडिया। भले हमारा क्रिमिनल फिर किसी भी नेशन में भाग के छुपा क्यों ना हो, लेकिन हम अगर उसने इंडिया में क्राइम किया है तो उसको पकड़ने के लिए दूसरे नेशन से भी पकड़ के उसका सजा दे सकते हैं। दैट्स कॉल्ड एक्स्ट्रा टेरिटोरियल जुरिस्डिक्शन। ओके, देन inter-territorial jurisdiction क्या है? The crime that is committed within the territory of India and the courts in India is trying that person within the territory of India. If he is found guilty, he will be punished. That's called intra-territorial jurisdiction. So it is within the territory, within the territorial waters, or any ship or aircraft which is owned or registered with India. And it is not a defense for any kind of foreigner to say, I do not know what is a crime in India. See, crime is a crime in India. You have to know the law of the country where you are going. At least I'm saying criminal law. I'm not saying civil wrongs or something like that. Okay, and it is not necessary the law has to be published at every corner that every foreigners will read it. It's not necessary. See, sufficient publication out there, and today is the internet age, तो ये सब चीज़ें आपको available है। इसके साथ साथ ये भी ध्यान रखना व्हाट इज द एग्जेम्पशन टू द इंट्रा टेरिटोरियल जुरिस्डिक्शन। सो आर्टिकल 361 सब आर्टिकल 2 के हिसाब से कॉन्स्टिट्यूशन प्रोटेक्ट्स क्रिमिनल प्रोसीडिंग्स अगेंस्ट द प्रेसिडेंट एंड द गवर्नर ऑफ द स्टेट। Okay, and in accordance with the well-recognized principles of the international law, foreign sovereigns are protected, and this immunity is also enjoyed by the ambassadors and diplomats of the foreign countries. An extraterritorial jurisdiction क्या होता है? Well, extraterritorial jurisdiction is where the crime is committed outside the territory of India, and such person has to be tried and punished within the Indian courts. So if anyone commits that kind of offense which is beyond the territory of India, it's an extraterritorial jurisdiction. And it is clear that the courts in India have an extraterritorial jurisdiction to try the offenses which is on overseas land, high seas, by the Indian nationals in other states or nations out there. Okay, so this kind of things आपसे आंसर में एक्सपेक्ट रहेगा, प्लीज इसको अच्छे से पढ़ के जाना। Okay, then yeah, this one. Explain the fundamental elements of crime. So basic function of crime is to deter the incidence of the crime, and crime is against human being. That is the first requirement of any crime to be established. It is against human being. It has to be proved that human beings are affected by the crime. Secondly, mens rea, a guilty mind, that is a act without a guilty mind cannot be punished as a crime. It can be punished in some other respect but not as a crime. So in crime the intention has to be proved, the mens rea element has to be proved. And other factors to be considered, yes, the factors called actus rea, that is an act or omission. Somebody has done something, human has done something, something which is a crime in the nature of society. Here rea means an unlawful commission of an act which is punishable in law. That's called reus or actus reus. So somebody has done something wrong and it is punishable. Okay, then yeah, this one, mens rea, or important part of mens rea. See, the basic principle of criminal liability system is that this act alone itself is not a crime unless it is proven guilty, and you have to prove it with a guilty mind. And Supreme Court in Girija Nath versus State has said that mens rea is a loose term. It covers wide range of mental states. So you have to find out which one is due for the actus rea. उस crime को करने के लिए पीछे क्या था, and what is the intention? Intention means what is the purpose, what is the act which is done, what was running behind that person while committing that crime, or what lead to the commission of that crime. वो intention का part होता है. And there are times when the act must have been done in negligence. Negligence, you can say, is a term जहाँ पे you did not take the due care which has to be taken, and the law does not allow that liberty, that freedom, that reasonableness in these kind of circumstances where negligence can affect any person's right or a legal right, or it can be affecting the person's conduct. And third thing is recklessness. Recklessness, वो आपने देखा होगा शराब पी के गाड़ी चलाते हैं recklessly. So recklessness occurs when the person who is doing that thing foresee the possibility of doing it and does it with a risk. So यहाँ पे recklessness comes into picture, and these three are the great elements of crime connected to the mens rea, because mens rea can be intention, it can be arising out of negligence, it can be a reckless conduct also. Okay, so इस वाले को अच्छे से पढ़ के जाना. This one. What is a corporate body or mens rea? Okay, and criminal liability for the corporate bodies. तो ये है क्या? Well, यहाँ पे according to section 11 of IBC, the person includes a company or any kind of association, और क्या कंपनियों को भी जेल हो सकती है. That's the intention of vicarious liabilities. So companies are covered by the provisions of Indian Penal Code. Virtually all kind of jurisdictions across the world can be governed by rule of law, and companies can be made a party to the crime if the principle of alter ego is being followed in this case. So it has to be proved that the person who was controlling the company had an intention that led to the company. Say state of Maharashtra versus syndicate transport, that there was an intention that led to the company into commission of the crime. So company has gained out of that crime is a part of making a company criminal in this case. And then yeah, what are the important stages of crime? So first, there are 4 stages. First is criminal intention. Intention is the first stage of the crime. Intention means doing some act with one's will, desire, malified. You want to achieve something and you did something wrong. That was the intention. And intention can also be imputed under the law. For example, if a man does a rash driving and resulting into an accident, it's a reckless driver. So there can be an intention, but a reckless driver cannot plead the innocence. I never knew that this could be leading to an accident. So there is an intention, and intention can be leading in this case also. Then yeah, preparation. Preparation means to arrange necessary measures which is intended for the criminal act. Preparation itself is not punishable, but if it leads to certain kind of actus rea, it is punishable. Something like this, that is preparation to wage a war, preparation of counterfeiting coins, preparation to counterfeit false coins, and preparation for dacoity itself is punishable. The fourth element in the crime is attempt. Attempt, or rather third element is attempt. Attempt is a commission of a crime. Attempt is a preliminary stage. Attempt means a direct movements toward the commission of the crime, and when a person makes an attempt after preparation, even an attempt can lead to a punishment. It has to be noted that certain attempts in a particular way are very much punishable in nature. And fourth element is commission of crimes or accomplishment. That is the last stage. You committed the crime, something has gone wrong, and the accused succeeds in committing the crime, and he will be guilty of the offense. And even if he's unsuccessful, he still can be held guilty if an attempt is proved. So these are the four elements that you should remember for your exams. Okay. Then apart from this, another thing to remember for the exam is, yeah, this one: presumption of innocence and burden. Okay, so there is a presumption of innocence in favor of a person who is an accused of a crime. It means that in the eyes of law, the accused is innocent until proven guilty. So this presumption has to be rebutted. It has to be proved beyond all doubts that this person has committed the crime. And if the accused has committed the crime, and while leading defenses also is unable to prove that he has not committed the crime, then the presumption can be rebutted against. Okay, so this is one of the questions. Do read it for your exams. And yeah, this one also: what are the various types of punishments to which offenders are liable in IPC? So there are various types of punishments, something like this: punishment of death. Death can be given for various kind of act, like murder, dacoity, waging a war against government, abetting mutiny, giving or fabricating false evidence, abetment. So it is a capital punishment. It is covered in two categories. Okay, it can be treason or it can be a murder, and in either case the court decides the death penalty on the appropriate sentence in the light of gravity of the matter, how serious the matter was. Okay. Secondly, you have to pay attention to life imprisonment. The imprisonment of life is meant for a rigorous period. It lasts to the breath of the convict. That is, you will be hanged until death. That's called death punishment. But if it's a life imprisonment, you will be put into the bars or in jail for as long as you are alive. So that could be a life imprisonment. And imprisonment can be rigorous or it can be simple imprisonment also. And there can be forfeiture of properties. That is the divestiture of the property of the specific compensation. So if the state is demanding a compensation, and if the person is not able to pay, so the forfeiture of property can be executed. And yes, fines is money collection. It is imposed on individual, or it is not a collective duty. It's imposed on individual's conduct. It's a fine which is the amount which is determined if something is wrong done by the individual. So there are fines which is also imposed. Okay, then apart from this, do read this one. Yeah, this one. So what is the punishment for criminal conspiracy? 120B. See, whoever does a criminal conspiracy, what is a criminal conspiracy? So here it is a definition of criminal conspiracy. So criminal conspiracy is that if a person is doing something illegal act or acting which is by illegal means, okay, illegal act, illegal means, and no agreement except an agreement as to commit an offense shall be considered as criminal conspiracy, and it is immaterial whether illegal act is an ultimate object or not. And Supreme Court in its case has given that the agreement between two or more persons for doing or causing to be done an illegal act on which is not a legal thing can lead to a criminal conspiracy. So what is the punishment for that criminal conspiracy? Well, whoever is found punishable, then the punishment for the criminal conspiracy, including that of the abettor of crimes, can run into 6 months or not exceeding 6 months of fine, or with both. So remember this one for criminal conspiracy. Okay, and yeah, do this one also. That is dishonest misappropriation of property, section 403. So as per section 403, if a person dishonestly misappropriate a property, convert to his own use any kind of movable property, that person can be punished for a 2 years imprisonment or with both. And then there are a good number of illustrations that you can see for the exams, and there is an explanation. Well, here the explanation clarifies some things. That is, a dishonest misappropriation for a time is only a misappropriation within the meaningless. That is, it has to be misappropriation of a time being, of the time. And then illustration is given. Explanation 2 is that a person who finds the property which is not in the possession of the other, and he takes the property for the purpose of protecting it, for restoring back to the owner, does not amount to a misappropriation for a dishonest intent. that person is not guilty for the offense. But if he's guilty for the offense, if he appropriates the property for his own use, when he knows that the property after discovering does not belong to him, is not returning back the property, that is when the person is held to be guilty. Okay, and yeah, it is not necessary that the finder should uh, know that the property is that of a particular person or the owner. It is sufficient that if he is appropriating the property for his own use and he knows that this is not his property, then he is guilty of the offense. Okay, and then yeah, you can read the illustrations. There are a good number of illustrations. Okay, do read them, because these things becomes case-based questions in your exams. Okay, and yeah, dishonestly is an what is the meaning of dishonest? Dishonestly is an essential ingredient of this section. So if a person does anything with the intention of causing a wrongful gain to one person or a wrongful loss to the other person, that is dishonest. That is dishonest. Okay, and the two things which is necessary for 403 is that the property must be converted to the use of the accused, and he must misappropriate the property to convert it dishonestly. Okay, and then there are some case studies that you can read it. Bhagiram case, it has been held that 403 section takes place when the possession has been innocently come, but where the subsequent change of the intention, some new factors come into picture which was not there previously, the retaining can become wrongful. So if you take a property, if you take a movable property of somebody else, you may not have an intention at that moment, but later on if you develop an intention, yes, it can lead to dishonest intent. And so also in the case of Muhammad Ali versus State, do read these cases, and New Dhar versus, these have been past exams cases, so please read them before you go for your exams. Okay, this has been past exam cases, and please read them before you go for your exams. Yeah, then this one, write a short note: dishonest misappropriation of property by the deceased person in the time of his death. So what happens here, that if there is a dishonestly misappropriation or conversion of a property, knowing that the person is dead at the time when this conversion has happened, and he is not in the possession, and the person who is in the possession should not be in the possession of the property. Later it comes to know that this person has dishonestly misappropriated the property. That person can be punished with an imprisonment for 3 years, or liable to fine as decided by the court. Okay, so this is where the person is dead at the time of misappropriation of property. Okay, and this is the illustration in nature there too. Okay, so do read these questions. These are important questions. And going ahead, yeah, do read this one also. What are the essential ingredients for offense of criminal breach of trust? So see, the essential is the accused must be entrusted with the property, the person to entrusted use the property, accused dishonestly dispose the property, and if the direction of law is given. So do read section 405, another important part. So what is happening? यहाँ पे somebody, the accused is given the property is with the accused, but he dishonestly disposes of the property without a lawful title thereto. Okay, and do read these cases in support. These can be some of the important cases that has happened in your past exams. Okay, so please read these cases also in support. Clear? And the summary of the entire provision is given over here. So after analyzing the cases and the offense, it is said that the person who is handling the property must have some confidence that the person who is giving the property to create a fiduciary relationship. Secondly, the accused must be in such a position that would exercise a control over the property, kind of dominion over the property. And the property includes any kind of movable or immovable property. And it is established that the accused dishonestly put the property to his own use, to some unauthorized use. That's where the section comes into picture. Okay, so do read that, and yeah, read this one. This is a good case also. So A is a warehouse keeper. A is going on a journey, entrusted and under a contract, and it shall be returned on the payment of the stipulated warehouse. Before coming Z from the journey, he sold the furniture. What offense he is committed? Remember, such kind of questions will be given in exam. They will not tell you the nature of offense. Rather, they will ask you what is the nature of offense. So you have to remember that what exactly has happened. The best way to remember is reading the examples to these sections. This is also coming from one of the examples. So if you read examples, you will know what section has to be applied, what kind of offense that has happened. So it's a criminal breach of trust. So if a person in any manner entrusted with the property or any kind of dominion of the property, and that person dishonestly misappropriates the property or dishonestly uses the property, which is a violation in the law, then it is said that he is doing a criminal breach of trust. He is breaching the trust of the other person. Okay? And whoever commits a criminal breach of trust can be given punishment to the extent of 3 years. Okay, so these are the cases that can be asked. It was a December 20 case, so do read that case. Okay, clear? Then, yeah, do read this one also. What is cheating? Cheating is an offense relating to the property that the accused merely get the possession of the property. And 415 gives you a general definition of cheating. Cheating is deceiving someone fraudulently. Is delivering a property to someone. Okay, it's a deceiving someone fraudulently and delivering the property to someone without the consent of the owner, without the consent of the person who has the rightful of property. So that's called a cheat. A cheat, there is a dishonest concealment of facts within the meaning. That's called cheating. And do read the examples to this one. Huh? Do read the examples. These are the certain examples. Please read them before your exams. They are very important examples. Okay, so they are very important examples. Please read them before your exam. Clear? Fine. And then, yeah, do read this one also. What is cheating by personation? So if 416 says if any person is pretending to be someone, knowingly substituting someone, representing himself to be someone, that's called personation. That's called cheating by personation. Okay, and read the explanation. That is, offenses committed where the individual personated a real or a imaginary thing also. And an example is given, so do read that. And please read this one also. That is called cheating and dishonestly inducing delivery of a property. So section 420, very famous section, that a person cheats and thereby dishonestly induces the other person to deliver the property, to make either or alter or destroy the property as a whole for a which is a valuable security, and which is signed and which is sealed and which is capable of converting into a security. So if somebody falsely signs, falsely seals, does something dishonestly, that is punishable as a 420 section. That is, imprisonment can run up to 7 years. So that is there. And yes, simple cheating is punishable in 417, and section 420 comes in operation when there is a delivery or destruction of the property or alteration or destruction of a valuable security. So that is a basic distinction how 420 is different from 417 or 415. 415 is a very general one. And do read these cases. The Korean Kacho versus State of Kerala, Muhammad Ibrahim versus State of Bihar, or Shruti Enterprise versus State of Bihar. These are certain important cases. Please read them for exams. Okay, and yeah, this one is also important. 421, dishonest, fraudulent removal or concealment of the property. Here it is that if some person fraudulently removes or conceals or delivers any kind of property, and he transfers it without any adequate consideration, and the property is distributed not in accordance with the law, then there is a punishment for that. So that's dishonest. Guwahati High Court has given that the accused removed, concealed the property. There is a transfer without consideration. The accused intended to prevent or knew that he was preventing the distribution and acted dishonestly, fraudulently. This section comes into picture. Yeah, this section comes into picture. So do read them. And then, yeah, this one, forgery. 463. What is forgery? If somebody makes a false document, false electronic record, false any kind of document, or damages or causes injury to any kind of public document, okay, or claims a title to any kind of document which he or she is not entitled to, and enter into any kind of contract to commit a fraud, it's a forgery. Okay, it's a forgery. So do read forgery. And yes, what is the punishment for forgery? 465, it is punishable for 2 years. And read these cases: Ramchandra State, Parminder Kaur State, and Balbir Kaur. These are very good cases and duly covered. Please read them. It's there in the module also. I've covered it in the notes so that you know these cases, and when such things come before you in exams, you will be able to handle them. Okay, so that is important questions that you have to read. And yeah, we go ahead. So here, yeah, this one. What are the general exceptions to the person accused of committing offense? See, this is called a kind of a defense system. So if a person is accused of committing offense, he can say that the particular offense was committed in certain circumstances. So Indian Penal Code provides general exception for the person accused of committing an offense, and in general exceptions, the absence of mens rea on the part of the wrongdoer can be assumed. Okay, and yeah, this one. Uh, the exceptions, strictly speaking, are six categories: judicial, mistake of fact, accident, trifling act, consent, and absence of criminal intention. So these are the broad categories that is covered, and this is how it is. So it can be a mistake of fact which is bound by law, that is, you did something which was bound by law, but you factually mistaken to understand it. Or it can be an act of judge acting judicially, and the judge did maybe acting within the good faith that he has an authority but he does not have one, or an act which is done pursuant to the judgment or the order of the court, or a mistake of fact which is justified by law, or an accident in doing a lawful act. So what exactly are these? These are some of the instances where you have done an act, but there is no question of mens rea coming into it. So when there is no question of mens rea coming into picture, okay, this is called mistake. An act which is likely to cause harm but done without a criminal intent to prevent the other. So you have done something which may cause an harm to the other person, but you had no intention to cause the harm to the other person. Okay, an act of a child under the age of 7 years or 82 years. So yes, that could be general exception. An act of a child above 7 years but 12 years, that could be another general exception that could be covered. And an act of a person of an unsound mind. Yes, a person of unsound mind could be made punished for an act which has been done in this nature. Okay, an act of a person incapable of making a judgment of for any kind of intoxication. Okay, that could be covered. Or an offense requiring a particular intent or the knowledge which has been committed, maybe knowingly or unknowingly. Okay, an act not intended to be known to likely to cause death. That is, maybe the doctors have done something but they never expected that they will be killing someone, rather they were saving the life, but it caused death. That's a general exception. And an act which is not causes death but done by the consent of the person's benefit. So sometimes such kind of risky things comes into picture, that's also there. And yeah, the example of a surgeon is also given. And on the consent of the guardian, if any act is done in good faith, if the act is done in good faith for the benefit of any kind of child or any kind of person of unsound mind, it is considered as a or act which is done with the consent. So if the act itself is done with the consent of the other party, it cannot be said to be criminal intent is there. Or any kind of act which is exclusion of the act which is independently caused harm. So if we do an act which is not causing harm to anybody, then it is excluded. An act which is done in good faith for the benefit without the consent is caused. Any kind of communication which is made in good faith, okay, like a surgeon makes a communication that, yeah, he believes that he will not be surviving for long, and suddenly that person gets a heart attack. So it's not that he wanted to kill the other person, but the communication has to be made. So an act which is compelled by threat, or act which is causing slight harm. Okay, so these are the certain questions that you should do. And amongst the latest thing that they have asked, so this one, define a criminal conspiracy. It was a December 21 4 marks. Do read that question. And what is the punishment? See, very simple, we have done that, and do read it. And another one, December 21, again 4 marks. Look at the case. Look at the case. A warehouse keeper, Z, is going on a journey, entrusts his furniture to A under the contract that he shall be returned on the payment and stipulated sum of warehouse room. A dishonestly sells the goods for the offense. So this case is an example to the very content of criminal breach of trust. Okay, December 21, 4 marks question. Do read that. Do read it. I'm not kidding. Do read that. Sometimes the questions repeats also. And yeah, this one briefly explain the intra-territorial and the extraterritorial application. So we started our discussion with one of these topics. So please read that for your exam. What is the intra and extraterritorial? June 22, 4 marks. And yeah, see another one. A is under a bona fide belief that certain property belongs to him, and the purchaser also under the same belief that the purchased property is from A. Subsequently, real owner C files a complaint of cheating against for the false sale deed. Whether A is liable for punishment, so there is a bona fide belief. Now, you have to have the hint. There is a property, the property which is being demanded by, and there is a complaint that sale deed is there, so it gives a hint that it is a 420 ka case. A person cheats with a dishonest intent if trying to deceive somebody from the valuable security or a property which has been signed or sealed. Okay, that's 420, and this is a case which we have already stated about, the Muhammad Ibrahim versus State of Bihar. That's what I'm saying. Read those cases and read the entire content if possible, but read this much you should read, and these are the important questions for your exams. Okay, so please read them well for your exams. And apart from this, I would suggest read the entire chapter well enough, because this is another top rated chapters in JIGL. Okay, so all the best for your exams. I'm sure you're studying very hard. May this help you further.